Welcome to the SA Mining Desk, your essential partner in understanding South Africa's mining sector. We're a platform dedicated to simplifying the intricate world of mining, from government regulations and groundbreaking judgments to essential industry reports. We deliver clear, concise information to equip you for every step of your mining journey. Join your host, he unpacks the mining sector for us.
Hi everyone, and welcome back to SA Mining Desk, your partner in navigating the South African mining sector. In our last episode of the Case Files series, we looked at the case of Limpopo 5 versus Sandhawks High Court and Sandhawks versus Limpopo 5 SCA. We learned something important there. When the regional manager accepts or rejects an application, they are mainly just doing a clerical check, like sorting mail. This means their decision isn't absolutely final, and they can correct any errors. However, even if it's not final, it is an administrative decision under the Mineral and Petroleum Resources Development Act, MPRDA, and the Promotion of Administrative Justice Act, PGM, because it can impact a right. Crucially, we also saw that a correct application doesn't lose its spot in the queue just because of an administrative error. Today, we're diving into the judgment of Platmin South Africa and another versus Samancor Chrome and others. At the heart of this dispute is a piece of land called the Grootboom 336 KT, situated in the magisterial district of Lydenburg in the Limpopo province. The geology here is the main problem. The minerals Chromite for chrome and PGMs, platinum group metals, are so closely mixed that when you mine one, you're inevitably mining the other. The situation got complicated because two different companies ended up with mining rights on the very same farm. One to mine for chrome and associated minerals, and one to mine for PGMs. This naturally led to a major question. How can we tell when a company is done mining the chrome and is only left with the PGMs? This case was heard by Judge Motha in the Gauteng Local Division, Johannesburg, with the judgment issued on November 12, 2025. It's important to stress that this ruling was about an interdict, a temporary court order put in place until a final review of the whole matter is completed. Let's begin. When the MPRDA took effect in May 2004, Samancor Chrome held an old order mining right for chromite on the farm. Under the old law, this right also let them sell any other minerals found alongside the chrome. Platmin, then called Boyston Investments, held an unused old order right for PGMs, gold, nickel, and copper on the same farm. Under the new MPRDA rules, Samancor had 5 years until May 1, 2009 to apply to convert their old right. Platmin had a much shorter time, only 1 year, until May 1, 2005, to apply for a new prospecting or mining right. Platmin missed this deadline, and their unused right lapsed. Almost a year later, in February 2006, Platmin applied for a new prospecting right for PGMs and other metals, which was granted in November 2006. They then applied for a mining right, which was approved in October 2008. All this time, Samancor's old order mining right was still valid. Samancor finally applied for their conversion in July 2007, and their right was converted into an MPRDA mining right in July 2009. Crucially, under the MPRDA, this converted right only allowed Samancor to mine chrome, not the associated minerals like PGMs.
Years later, on March 18, 2020, Samancor applied to amend their converted right to include those associated minerals. This amendment was granted and issued in August 2020.
Then, in March 2024, Platmin's mining right was renewed until 2053. The result? Between August 2020 and March 2025, both Platmin and Samancor shared the right to extract PGMs from the Grootboom farm. To summarize, Samancor's old right for chrome and associated minerals, like PGMs, was in place alongside Platmin's unused old right for PGMs. Platmin let their old right lapse, but then got a new one. Samancor converted their right, but for a period it only covered chrome. Eventually, after Samancor's amendment, both companies held the right to mine PGMs on the exact same piece of land. Samancor and Platmin both lodged internal appeals against various decisions made by the Department of Mineral Resources. Platmin appealed the decision to amend Samancor's right to include associated minerals. Samancor appealed the original decision to grant Platmin a mining right and the decision to renew it. On March 27, 2025, the minister made a final decision. Platmin's appeal was successful and Samancor's was dismissed. The minister essentially said, granting the amendment to Samancor resulted in two companies having rights for the same mineral in the same area, which goes against the act. Samancor immediately launched a review application to the High Court against the minister's decision, and those proceedings are still pending.
Because the review will take time, Platmin applied for a temporary court order, an interim interdict, to stop Samancor and a related company, Sylvanium Metals, from mining, taking, or selling PGMs for their own benefit from the farm. Platmin argued that they owned the PGMs and claimed Samancor was selling ore called lumpy and chip, which hadn't been processed enough to separate the PGMs from the chrome. Platmin argued that the ore must be ground down to a very fine material, or sub 1 millimeter, before the PGMs can be separated. By selling the larger, unprocessed chunks, Samancor was effectively selling Platmin's PGMs for free or without consent. Samancor filed a counter-application asking the court to stop the minister's decision from being implemented until the final review was done. Samancor claimed that completely separating the minerals is often impossible or financially impractical. They also argued that the interdict would make the mine unprofitable, forcing it to close and causing job losses. They relied on the concept of civilir relodo, which basically means exercising your rights in a way that causes the least possible harm to others.
The court ultimately granted the interim interdict in favor of Platmin and dismissed Samancor's counter-application. Samancor was interdicted from selling Chuck's chrome, which still contained PGM, and required to process the chrome to sub 1 millimeter, at which point PGM is assumed to have been removed. It now remains to be seen what the final outcome of the main review proceedings will be. We're certainly looking forward to that final ruling. Please leave your thoughts on this matter in the comments. We would love to hear from you. See you next time.